Shall we start? Okay. Now let's look at the global picture. What is the status of fundamental rights in England, the United States, and India? Let's look at England to begin with. In England, we say there is no code of fundamental rights. The foundation of fundamental rights in England is said to be negative. Negative in the sense that an individual has the right and freedom to take whatever action he likes, so long as he does not violate any rule of the ordinary law of land. What does that mean? In England, you will know they have an unwritten constitution. And a country where the constitution is unwritten, who is more powerful, constitution or the parliament? Who is sovereign, constitution or the parliament? It is the parliament, which is sovereign. This much is clear? 100%. Now let's look at India, for example. We have a set of fundamental rights. For example, right to equality, right against discrimination, right to freedom of speech and expression, cultural rights, educational rights. All these rights we will discuss. Only these are fundamental rights. Clear? Right to property is not a fundamental right. Right to interstate trade and commerce is not a fundamental right. Right to information is not a fundamental right. Right to work is not a fundamental right. So there is a clear-cut segregation. There are some fundamental rights, there are other rights as well. In England, we say everything is your fundamental right. Right to equality, right to freedom, right to press, right to marry, right to property, everything is a fundamental right. But the only thing is that they don't call them fundamental rights. And this right can be given by Parliament. Parliament can snatch these rights as well. In India, Parliament cannot snatch these fundamental rights. Those fundamental rights which are part of the basic structure of the Constitution. For example, the right to property previously was a fundamental right. It was deleted as a fundamental right in 1978. And I will tell you in directive principles what was the need to delete a right to property as a fundamental right. But be that as it may, there is a limitation on the powers of the Parliament. Parliament cannot delete those fundamental rights which are part of the basic structure. But there is no limitation on the power of the Parliament in Britain because they have an unwritten constitution, and in an unwritten constitution, Parliament can do anything except convert a man into a woman and a woman into a man. Let's say, for example, right to marry. Is right to marry a right in Britain? Yes. But if the British Parliament would explicitly state that same-sex marriage is not constitutional, same-sex marriage is not allowed, then same-sex marriage is not a fundamental right in Britain. Everything else becomes a fundamental right. That means in Britain, we can say that there is no code of fundamental rights. There is no segregation that some rights are fundamental, some rights are constitutional, some rights are statutory. Everything becomes your right. An individual in Britain can do anything. And anything that he does, whether it is to write a novel, to make a movie, to publish a song, to marry, everything becomes a fundamental right, except that which the law of Britain has explicitly prohibited. You cannot murder somebody and claim it as your right because a right to murder is not a right given by the British Parliament. You cannot indulge in theft because that is not a right given to you by the British Parliament. Everything else becomes your fundamental right. And in Britain, we say courts have the fullest power to protect the individual against the executive tyranny. But the courts are powerless as against legislative aggression upon fundamental rights. What does that mean? Listen to me carefully. For example, you have a right to make a movie. In Britain, for example, you have a right to make a movie. How can we say this is your right? Because British Parliament has not explicitly stated that you can't make a movie. If the British Parliament has not said explicitly, clearly that you don't have right to make a movie, which means this is your right. Because in Britain, you can do anything except those things which the British Parliament has prohibited you from doing. If the British Parliament has not prohibited you from making a movie, that means right to make a movie becomes your right. What if executive? For example, the police in Britain. I'm making a movie in Britain, but the police comes and arrests me. Why have you made this movie? I will go to the court. My lord, my right has been violated. I said, what right? Right to make a movie. How do you say that is your right? Because the British Parliament has not explicitly said that you don't have the right to make a movie, which makes right to making a movie my fundamental right. And the police has arbitrarily arrested me for making a movie. The court will set me free. Said, how dare you arrest this individual? Don't you know he has a right to make a movie? Because the British Parliament has not prohibited him from making a movie. So if the executive has violated your rights, the courts will come to your rescue and protect your rights in Britain. But what if tomorrow British Parliament makes a law and says right to make a movie is not a right? There is a prohibition on you from making a movie. You cannot go to the court. My lord, British Parliament has done something, passed a law, and they're saying that you can't make a movie. Please protect me. Courts will say, I'm powerless. What can I do? British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament is sovereign. In an unwritten constitution, it is the Parliament which is sovereign, which is supreme. If the Parliament has said you don't have the right to make a movie, we are helpless. That means the British courts will protect an individual if executive has violated your rights, if the police has violated your rights, if the government has violated your rights. But the courts are helpless, powerless if these rights are snatched by the Parliament, if the legislature is snatching your rights. So long story short, we can say in Britain there is no fundamental right which is binding on the legislature in England. British Parliament can do anything. Give you the right to life, snatch your right to life as well. Give you freedom of speech and expression, snatch this right as well. Give you the right to make a movie, snatch this right as well. Give you the right to have a same-sex marriage, repeal this right as well. There is no right which is binding on the Parliament in Britain, because in Britain, Parliament is sovereign, Parliament is supreme. So fundamental rights, which are very important for the growth and development of an individual. These fundamental rights, are they present in England? We say in England there is no such thing as fundamental rights because they do not divide rights into fundamental rights, constitutional rights, other statutory rights. So that means we say the foundation of individual liberty in Britain is said to be negative. That means an individual has the liberty, has the freedom to do anything except what the legislature has prohibited. So you can do anything that the legislature has allowed you to do or not prohibited you from doing, and you can claim that all these are your rights. And if the executive, if the government, if the police is violating these rights, you can go to the court, courts will come to your rescue. But what if these rights are snatched by the legislature in England? The courts are helpless, powerless to come to your rescue because there is nothing binding on the British Parliament. Because British Parliament is sovereign, it can do anything. But when we contrast this with, you can look at the slide, there is no law in England which Parliament cannot change. That's why D. Lolme said the British Parliament can do everything except make a woman a man and a man a woman. In short, there is no right which may be said to be fundamental in the strictest sense of the term. There is no right which cannot be snatched by the British Parliament. But when it comes to the United States of America, the framers of the US Constitution, because in England, courts will protect you against the actions of the executive, against the illogical actions of the executive, against the arbitrary actions of the executive. But the courts in Britain are helpless against the legislature. But the framers of the US Constitution, which is the oldest federal constitution of the world, written constitution, the framers of the US Constitution, they wanted to protect the citizens of US from the onslaught of executive as well as the onslaught of legislature. And that is why they have something known as the Bill of Rights, a list of fundamental rights, which they call Bill of Rights. Freedom of press is explicitly mentioned in the US Constitution. And what is that freedom of press? Which means freedom from censorship. Freedom from censorship in the sense, when emergency was imposed in India in 1975, when Srimati Indira Gandhi was the Prime Minister, any newspaper, if it was to be published, first the news items were shared with the government. Government, these are the news items that we need to publish. The government officials would look at these news items. Any line which was critical of the government was deleted, and then this copy was given to the newspapers. Now you can publish it. That is what we call censorship. That means restrictions on the press, what you can publish, what you cannot publish, what you can type, what you cannot type. This cannot happen in United States because they have freedom of press, which means freedom from censorship, which means whatever they want to publish, they can publish. That is their fundamental right. And the framers of the US Constitution said these Bill of Rights are equally binding on the legislature as well as the executive. If this freedom of press is violated by the executive, the courts will come to your rescue and protect your fundamental rights. What if tomorrow US Congress, US Parliament wants to snatch this right? The courts will come to your rescue and say, how dare you snatch this right? Because this is part of their Bill of Rights. This is fundamental to the citizens of United States. Which means in the United States, they have a concept of judicial supremacy as against parliamentary supremacy. Which means any law which is passed by the US Congress, US Parliament, if it violates these Bill of Rights, if it violates these fundamental rights, you can go to the court and the court will come to your rescue. Whether executive is violating your fundamental rights or legislature is violating your fundamental rights, you don't need to worry because you are the citizen of United States, and in United States we have a judicial supremacy, which means the US courts will come to your rescue and protect your fundamental rights against the onslaught of legislature, against the onslaught of executive as well. Similarly, when it comes to India, our constitution follows the American model rather than the British model. But the powers of judiciary vis-a-vis legislature are weaker in India than in United States. How? Listen to me carefully. We have a list of fundamental rights. Can these fundamental rights be violated by executive? No. Can these fundamental rights be violated by legislature? No. If they're violated, you can approach the Supreme Court. Supreme Court will come to your rescue, protect your fundamental rights. But in India, fundamental rights are not absolute. Listen to me carefully, very important point. Fundamental rights are not absolute. What do we mean by absolute nature of fundamental rights? Which means there are restrictions which are known as reasonable restrictions. What are these reasonable restrictions? For example, we have a fundamental right, Article 19(1)(a), which is known as freedom of speech and expression, which we will discuss on Thursday possibly or Friday, which means you have the freedom to say whatever you want to say. You have the freedom to express whatever you want to express. You have the freedom to write whatever you want to write. But this right is not absolute. That means it doesn't mean you can write whatever you want to write. There are some restrictions. Restrictions such as public order. What does that mean? One classic example. We are watching a movie in a multiplex. Let's say it's the new Shah Rukh Khan starrer Jawan or Pathan, which is the latest movie, Pathan or Jawan, whatever Nan, we're watching that movie. And suddenly I'm having popcorn as well, and I start shouting, fire, fire, fire. What will happen in the multiplex? There will be stampede. People will start rushing towards the exit. Ultimately, there will be stampede. People will come on each other. Some will be without any breath, and ultimately some people may die as well. I'm sitting very calmly on my seat, having popcorn and a glass of Pepsi or Coke or whatever, and I see all this ruckus going on. Then the police comes, and police starts arresting me. But why are you arresting me? Why did you cry fire, fire, fire where there was none? Don't you know through your actions it has led to the unfortunate deaths of 20 people? 30 people have been injured. The multiplex has suffered a loss. There is a chaos because of your utterance, because of what you cried, fire, fire, fire. I would say, look at the Constitution. Article 19(1)(a), freedom of speech and expression. I spoke fire, fire, fire. I expressed because that's my freedom. The police will have a slap against me and said, how dare you? Don't you know this right is not absolute? There are restrictions. Through your freedom of speech and expression, you cannot violate public order. Tomorrow you will say, let's raise arms, AK-47, and kill these politicians. You can't say that because you are then instigating people to violence. You can write whatever you want to write. You can express whatever you want to express. You can say whatever you want to say. Sing an Arijit Singh song. Why do you want to cry fire, fire, fire where there is none? Ask people to fight corruption. Why are you asking people to kill the politicians? You're inciting people to violence. So this right of freedom of speech and expression is not absolute. There are restrictions, and those restrictions are known as reasonable restrictions. But who can impose these reasonable restrictions in India? Parliament. Initially, when the constitution was enacted, there were 4 grounds on the basis of which your freedom of speech and expression can be restricted, which we will discuss later. 4 additional grounds were mentioned when the parliament amended the constitution. That means 4 additional reasonable restrictions were imposed on your fundamental rights. By whom? By the parliament. But in United States, if there is a restriction on your Bill of Rights, if there is a restriction on your fundamental rights, those restrictions cannot be imposed by the parliament. Those restrictions can be imposed by judiciary. Judiciary can impose restrictions on your fundamental rights, not the US Congress, not the US Parliament. But in India, we say we have a list of fundamental rights. These fundamental rights are equally binding on executive, equally binding on legislature as well. Neither the executive nor the legislature can violate these fundamental rights. But if there are restrictions to be imposed on fundamental rights, those restrictions can be imposed by the legislature, by the parliament, not the judiciary. But in US, it's the reverse. Restrictions on your fundamental rights can be imposed by judiciary, not by the parliament. That is why we say in India, the powers of judiciary vis-a-vis, with respect to legislature, are weaker in India than the United States. And that is why this paragraph, while the declarations in the American Bill of Rights are absolute, that means the freedom of speech and expression in United States is absolute. Say whatever you want to say. They can even burn their national flag. They can even use their national flag as an undergarment, which is something that cannot happen in India. Because if you do that, you will be punished for violating the Protection of National Honor Act. So that means the Bill of Rights are absolute in United States. And the power of the state to impose restrictions upon these fundamental rights have to be evolved by the judiciary. The judiciary can evolve these restrictions, can impose these restrictions. While in India, this power has been expressly conferred upon the legislature by the Constitution itself. Constitution itself says if there are restrictions to be imposed on fundamental rights, those can be imposed by the parliament. But there is still a power given to the judiciary in India, and that power is known as judicial review. So Constitution, listen to me carefully, Constitution has given the power to the Parliament of India that you can impose reasonable restrictions on fundamental rights. What if restrictions are imposed by the Parliament? Restrictions can be imposed by the Parliament. Restrictions can be imposed by the Parliament alone. But are these restrictions reasonable or not? That the judiciary will decide in India through its power known as the judicial review, where the judiciary will review the laws passed by the parliament to see whether those restrictions which have been imposed on fundamental rights, whether those are reasonable or unreasonable, just or unjust, fair or unfair. Long story short, we are discussing a chapter known as fundamental rights. But fundamental rights, DPSP's fundamental duties. Although these are different parts, distinct units, part 3, part 4, part 4, capital A, yet when we look at them together, we say that they are used to concretize, to give shape to the lofty goals of justice, liberty, equality, fraternity, dignity, which are mentioned in the preamble to the Indian Constitution. And fundamental rights basically are negative obligations, restrictions on the powers of the state. State, don't interfere with the life and liberty of an individual. State, don't discriminate. State, don't deny equality. State, don't deny and deprive an individual of his right to life and personal liberty. Don't do this, don't do that. What are these? Limitations, restrictions, negative obligations on the state. But are there fundamental rights present in other countries as well, in the constitutions of other countries? Yes. When we compare it with England, because we have borrowed a lot of provisions from England, and when we compare it with the US, because we also claim ours is a federal constitution, just like United States of America, when we compare our fundamental rights with these countries, we see that there is a commonality, there is a difference as well. In England, there is no segregation of rights into fundamental rights, constitutional rights, other statutory rights. In Britain, you can do anything, and everything is your fundamental right, except those things which the Parliament of Britain has prohibited you from doing. Because British Parliament, in an unwritten constitution, is sovereign. It can do anything. But in United States, there is Bill of Rights. But can restrictions be imposed on these rights? That is for the judiciary to decide and evolve, not the legislature. And these Bill of Rights are absolute without restrictions. No restrictions imposed by the legislature. If at all restrictions are to be imposed, can be imposed by the judiciary. In India also, we say that there is a list of fundamental rights. Neither the executive nor legislature can violate these fundamental rights. But these fundamental rights are not absolute. And if restrictions are to be imposed which are reasonable on these fundamental rights, that can be done only by the parliament. With the power of judiciary, that they have a judicial review. They can review this law passed by the parliament to see if this reasonable restriction was indeed reasonable, if this restriction was just, if this restriction was fair. That is the difference between the three countries. Any questions as of now? What is a convention? Convention is an unwritten rule, not mentioned anywhere, but something that we follow. So why is it that some rights are exclusively available to citizens but not to aliens? We will discuss that today. No question, crystal clear, all clear. In India, there is a mix of judicial supremacy and the parliamentary supremacy. In a sense, yes, parliament can impose restrictions with the power of judiciary to decide whether these restrictions are reasonable or not. But if you want to understand it deeply, for that, you will have to discuss this chapter, judiciary. There we will have a clear picture, and there we will conclusively prove that in India, judiciary is more powerful as against any other institution. Why it is different for armed forces and paramilitary forces? We'll discuss. Fundamental rights are not absolute. There are restrictions, exceptions. Let's explain all these fundamental rights one by one. First, we will talk about Article 12. And what is Article 12? Throughout this chapter of fundamental rights, you would come across this term known as the state. The state shall not deny equality before law. The state shall not discriminate. The state shall not discriminate against the citizens only on the grounds of religion, race, caste, sex, place of birth. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. Who is this state against which your fundamental rights are enforced? Who is this state? If it violates your fundamental rights, you can go and knock the doors of the Supreme Court directly. Who is the state against which your fundamental rights are enforced? The definition of that state is given under Article 12. And Article 12 talks about the state includes, so that you are not confused with that, is this the state of Karnataka or is this the state of Madhya Pradesh or is this some other state? What is this term state which is mentioned in the fundamental rights chapter against which your fundamental rights are enforced? Which means if this state is violating your fundamental rights, you can drag the state to the court. Article 12 says the state includes the government and parliament of India. Which means if the prime minister and his ministers and the members of the bureaucracy who are part of the government, if the parliament, which is Lok Sabha, Rajya Sabha, president, if they violate your fundamental rights, drag them to the court. State also includes the government and legislature of all the states in India. Whether it is the chief minister of Karnataka or the legislative assembly of Karnataka, whether it is the chief minister, the government, the bureaucrats of UP led by the Yogi, or it is the legislature of Uttar Pradesh which is violating your fundamental rights, drag them to the court. Or all the local authorities, even if it's a Panchayati Raj institution, even it's a municipality, it is also under this definition state. If they violate your fundamental rights, drag them to the court. But the Constitution under Article 12 talks about something else. It talks about other authorities within the territory of India or under the control of the government of India. Article 12 talks about the definition of state. State in the sense, Constitution says throughout this chapter of fundamental rights, state cannot do this, state cannot do that, state can do this, state cannot do that. Who is the state which cannot interfere with your liberty, which cannot snatch your fundamental rights. Article 12 explains that in the definition of state, saying state means government of India and parliament of India, government of state and legislature of the state, local authorities, panchayati raj institutions, municipalities. Article 12 also says other authorities within the territory of India or under the control of the government of India. Which are these other authorities? Not mentioned in the constitution. But who is the final interpreter of the constitution? Who is the final interpreter of the constitution? Very good. The answer is Supreme Court. That is why in the first class I gave you the definition of a constitution. After all, what is a constitution? Constitution is what the Supreme Court tells us it is. That is a constitution. And constitution, what it is, these other authorities, Supreme Court in various judgments have now explained which are these other authorities which also cannot violate your fundamental rights. Because constitution says under Article 12, state includes the government of India, parliament of India, government of state, legislature of state, local authorities, panchayati raj and municipalities, and other authorities. Which are these other authorities? Supreme Court says, number one, that authority whose financial resources, where the state is the chief funding source, that means the entire share capital is held by the government. If there is an organization, if there is a company, where the entire control of that company is with the government, where the financial resources of the government are given to that entity. State Bank of India is a state. Reserve Bank of India is a state. Life Insurance Corporation of India is a state. Why? Because the principal source of funding for these institutions is the government. Majority stake in these organizations is with the government. It is a state. Which means even State Bank of India cannot violate your fundamental rights. Life Insurance Corporation cannot violate your fundamental rights. Reserve Bank of India cannot violate your fundamental rights. Or other authority means deep and pervasive control of the state. Where the state has deep control over such institutions. For example, Food Corporation of India, where the state has deep control. For example, the railways, where the state has deep control over railways. In fact, the state, we can say, enjoys some sort of control over railways, that it operates railways throughout the country. It is also a state, and the state cannot violate your fundamental rights. The functional character being governmental in its essence, meaning thereby that its functions have public importance and are of governmental character. What is the role of the government? To provide electricity to the people. What is the role of government? To provide healthcare facilities to the people. So government hospitals come under state. The electricity boards come under state. The pollution control boards come under state. All these entities whose primary function is governmental in character, they are also within the definition of the state. A department of the government which is transferred to a corporation. For example, previously, we used to have Doordarshan, All India Radio. We still have, but those were government departments. One government department was Doordarshan. One government department was All India Radio. Later on, both these entities, Doordarshan as well as All India Radio, they were transferred to a corporation, and that corporation was known as Prasar Bharati. Prasar Bharati Corporation. Prasar Bharati becomes a state. Our public sector undertakings become a state. Steel Authority of India Limited, Coal India, all these are public sector undertakings where the state is the chief source of funding, or the state controls the majority of the stake. All these are states. Or the state enjoys monopoly status. Any entity which enjoys monopoly status becomes a state. Monopoly in the sense, Indian Railways. Can any other entity run railways in India? No. Department of Atomic Energy, Only this department has the power, has the monopoly, complete control over atomic resources in India. Can a private entity in India make an atomic bomb? No. Can a private startup in India manufacture a nuclear weapon? No, because this is the monopoly of the state. All those entities which deal with manufacturing these atomic bombs or hydrogen bombs or these nuclear weapons, they come under state, and the state cannot violate your fundamental rights. This is the only thing that you should keep in mind, because after that it becomes so technical that you would be confused. After that it becomes so technical that you will become the lawyer of the Supreme Court, which ultimately is of no value whatsoever. For example, BCCI, Board of Control for Cricket in India. The Indian cricket team is basically not an Indian cricket team. It is the cricket team of BCCI, Board of Control for Cricket in India. And it enjoys a monopoly status. Monopoly status in the sense, can any other organization in India select an Indian cricket team except BCCI? No. Can any other entity in India organize official matches in India other than BCCI? No. Can any other entity operate or start a league such as the Indian Premier League in India except the BCCI? Yes and no. Yes in the sense no. No in the sense there was a time when Zee launched its own Premier League, which was even before the Indian Premier League was started in 2007 or 8. In fact, matter went to the court. Zee Telefilms versus BCCI. BCCI had to award contract to broadcasters who would broadcast Indian cricket matches or those matches which will be played in India. Zee Telefilms was also a bidder. Zee Sports. Star was also a bidder. Other channels were also bidders. They wanted to bid for the broadcast rights. Ultimately, Zee lost this bid. Zee approached the court and said BCCI has violated equality principle, justice principle, which is violative of fundamental rights. And as such, we're taking BCCI to the court. Now, the principal thing that the court had to decide now was to see if the BCCI is a state or not. Because in all this definition, what if tomorrow Byju's as an entity violates your fundamental rights? I have the freedom of speech and expression, you will claim. But I will mute you. I will not let you ask the question. I will block your questions. Can you claim that my freedom of speech and expression has been violated? Yes, you can. But can you approach the Supreme Court for that? No. Why? Because Byju's is not a state within the meaning of Article 12. Only the state, if it violates your fundamental rights, you can drag the state to the court. Others can violate your fundamental rights. For example, this is the government property or government accommodation. For example, now the government has to give this accommodation to the people so that people can stay. Can the government say that this accommodation is available only for those who are Hindus? No, because the state is then discriminating on the grounds of religion, which the state cannot do. But if this is not the government accommodation, this is my accommodation. This is my private property. Can I say that I want to rent this property only to Hindus and not Muslims? I can do that. Am I discriminating on the grounds of religion? Yes, I am. But am I violating your fundamental rights? No, because I am not a state. If the state is violating your fundamental rights, you can drag the state to the court. Others, you cannot. Now, if BCCI has violated fundamental rights, first thing that the court had to decide was whether BCCI is a state or not. Because what is a state? Government of India, Parliament of India. Government of state, legislature of state. Panchayati Raj institutions. Indian embassies outside India as well. Or other authorities. Which are these other authorities? One such other authority is an entity which enjoys a monopoly status. Zee Telefilm said, BCCI enjoys monopoly. That means it's a state. And as a state, it cannot violate fundamental rights. But BCCI convinced the judiciary. BCCI convinced the judiciary by saying that although we enjoy monopoly status, but this monopoly status is not conferred by the state. If railways enjoy monopoly status, that status is conferred to railways by the state. The state has not conferred monopoly on BCCI. So when the state has not conferred monopoly on BCCI, BCCI is not a state within the meaning of Article 12. And as such, BCCI is not a state within the meaning of Article 12, under Article 12 of the Constitution. Indian Space Research Organization is a state. It cannot violate your fundamental rights. But you don't have to go too deep into the technicality because we will then lose the scope of this exam. You just have to keep in mind that when the state term is used in fundamental rights, who is the state that is mentioned in Article 12? And who is the state? The government of India, the government of state, Parliament of India, legislature of state, Indian embassies outside India, local governments, panchayati raj institutions, municipalities, those entities which are sufficiently funded by the government, for example, public sector undertakings, those entities, those departments of the government which are transferred to a corporation, for example, Prasar Bharati, and those entities which enjoy monopoly status. But that monopoly status should either be conferred by the state or should either be protected by the state. And if this state is violating your fundamental rights, you can drag the state to the court because the court will come to your rescue, protect, and safeguard your fundamental rights. Is that clear? What about legislature of Delhi and Puducherry? They are also state within the meaning of Article 12. Is judiciary included in the term state? That's a very good question. Listen to me carefully. Who comes to your rescue when your fundamental rights are violated? Judiciary. So an entity which comes to your rescue when your fundamental rights are violated, it is inconceivable, unthinkable to think that the entity which is meant to protect your fundamental rights is itself capable of violating your fundamental rights. That is why judiciary is not part of the state. Because judiciary is meant to protect your fundamental rights. And as a protector of your fundamental rights, can judiciary also be included in this term state? No. Why? Because an entity which is meant to protect, safeguard your fundamental rights, how can we even think that such an entity which is meant to protect your fundamental rights is itself capable of violating your fundamental rights? But then over a period of time, things have evolved. Evolved in the sense we say judiciary has two roles: administrative role and judicial role. Administrative role in the sense judiciary, its various parts, they're allocating cases to different judges. Members of the judiciary, they have property as well. On the administrative side, if they violate fundamental rights, they are part of the state. But on the judicial side, when they give judgments, you can't say that this judgment that you have given is violating my fundamental rights. I will drag you to the court again. So judiciary today plays two important roles. On the administrative side as well, how the cases are allocated. Allocated in the sense there is something known as master of the roster. Who is the master of the roster? Chief Justice of India. What does that mean? For example, at Byju's, we have this live online classroom program. I get to teach polity. Who gets to teach geography? I will decide it. For example, who gets to teach economics? I will decide it. Who gets to be your subject matter expert? I will decide it. So I become master of the roster. That means I allocate responsibilities to the individual teachers. I allocate responsibilities to the individual subject matter experts. I allocate responsibilities to various individuals who are developing and preparing content for this exam. Similarly, Chief Justice of India is the master of the roster in the Supreme Court. A case related to tax will be heard by which judge? That Chief Justice will decide. A case related to elections will be heard by which judge? That Chief Justice will decide. A case related to, let's say, corruption, a case related to land acquisition, a case related to constitutional matter, a case related to fundamental rights. Who are these judges who will get to hear these cases? That Chief Justice will decide. So Chief Justice is the master of the roster. He manages the roster. Who are these judges who will hear what sort of cases? That is the administrative side of the judiciary. There, if I do something violating fundamental rights, I am part of the state, I can be held accountable. But when I'm really hearing a case, I'm giving a judgment in Article 370 case, or in citizenship amendment case, or in EWS reservation case, I am not under the state because I am incapable of violating your rights, because I'm meant to protect your fundamental rights. That is why we say judiciary is not part of the state. But only on the administrative side, judiciary is part of the state. Is that clear? Clear. Okay. Now let's look at Article 13 of the Constitution. Laws inconsistent with or in derogation of the fundamental rights. There are 4 clauses under Article 13. Clause 1, 2, 3, 4. We'll discuss all the clauses, but you don't have to remember it clause by clause. Just understand the concept. What is Article 13? Article 13, Clause 1. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. What does that mean? I'll give you an example. When was the Constitution enacted? 26th January 1950. Because it was on this date that this chapter, Fundamental Rights, under Part 3 of the Constitution also got enforced. But when the Constitution was implemented, even before the Constitution was implemented, there were some laws which were already present. For example, Criminal Procedure Code. For example, Civil Procedure Code. For example, Indian Penal Code. Which now the government is trying to replace with the different set of codes, which we will also discuss. So Indian Penal Code, which was implemented in 1860. What is this Indian Penal Code? It's a set of laws. Set of laws in the sense, it provides, lists down punishment for all the offenses. Section 302 is for murder. Section 376 is for rape. Section 103 is for something else. That means for every crime, there is a punishment provided. And that is mentioned where? In Indian Penal Code. But what is Indian Penal Code? It is a law which was in force in the territory of India immediately before the commencement of the Constitution. Now, once the Constitution has been enacted, once this chapter, Fundamental Rights, has been provided, once all these fundamental rights under Part 3 have been provided, whether these laws will continue after 26 January 1950 as well or not. That's what Article 13, Clause 1 says. If there is a law which was in force in the territory of India immediately before the commencement of the Constitution, and now the Constitution has been enacted, once fundamental rights have been provided, can these laws continue after 26 January as well? Yes, if these laws are in agreement with fundamental rights. But if these laws violate fundamental rights, those laws cannot continue. And this is where we talk about a concept known as doctrine of severability. And what is that? Let me discuss. Yesterday, I gave you an example of Section 377 of Indian Penal Code, which talked about unnatural offenses. All those unnatural offenses which are against the order of nature. This was primarily used to target homosexuals or homosexuality, incest, bestiality, for example. Homosexuality, sex between men and men, sex between women and women, what is primarily known as the members belonging to LGBTQ community. It's an unnatural offense, or it was considered as unnatural offense against the order of nature, because that's not how the nature has created you. That's what the previous logic was. Incest, brother having sex with sister, mother having sex with son, father having sex with daughter, incestuous relationship. And this is no wonder that in European societies now incest is at its peak. It's considered against the order of nature because that's not how you do it. Bestiality, sex with animals, sex with dogs, donkeys, for example, horses, your pets. It is against the order of nature. It's a carnal intercourse against the order of nature, and as such, it is an offense. So this section 377 of Indian Penal Code, which was a law immediately prior to the commencement of the Constitution, can this law continue after the commencement of the Constitution? Yes. Yes, yes, yes. But the moment it violates fundamental rights, this law shall, to the extent of such inconsistency, be void. In 2017-18, Supreme Court in Navte Johar judgment said, homosexuality is not a crime. Right to love is also a fundamental right, regardless of the gender of your lover. So same-sex relationship is constitutional. Why? Because this section 377, insofar as it criminalizes homosexuality, it violates some fundamental rights which are provided under Part 3 of the Constitution. For example, Article 14, which deals with equality. Article 15, which talks about non-discrimination on the grounds of sex, which includes sexual orientation. Article 21, which talks about right to life and dignity. All these fundamental rights are violated, which means the section 377 is not continuing. But do you know section 377 still exists? Why? Because incest is still a crime. Bestiality is still a crime. That means we say this is doctrine of severability. That means if there is a law which has 10 clauses, 10 sections, if only 5 clauses are violating fundamental rights, only these 5 clauses will be cut. Only these 5 clauses will not operate. The remaining 5 clauses will continue. That means you are severing, you are cutting only those clauses, only those parts which violate fundamental rights. Remaining sections continue, remaining laws continue. Which means section 377, if somebody would tell you has been declared unconstitutional, it is wrong. Section 377 was not declared unconstitutional. Section 377 was read down. And what is that read down or reading down of a particular law? One part of it is unconstitutional, remaining continues. So we are reading down this law to say homosexuality is not a crime, but bestiality is still a crime, incest is still a crime. That is what we call doctrine of severability, and that is Article 13, Clause 1. Long story short, this is 26 January 1950. This is when the Constitution was enacted. This is when the fundamental rights were provided. This is the set of fundamental rights provided. Prior to the commencement of the Constitution, there were various laws. Indian Penal Code, Criminal Procedure, Civil Procedure, so many other laws. Can these laws continue after the commencement of the Constitution as well? Yes, provided these laws are in agreement with the fundamental rights. The moment these laws violate fundamental rights, those laws will be declared unconstitutional. But that does not mean the entire law will be declared unconstitutional. To the extent of inconsistency, this is where doctrine of severability comes into picture. Only those aspects of those laws which violate fundamental rights, those aspects would be read down. The remaining laws can continue. It is not that section 377, which criminalized homosexuality, it was read down by the judiciary. That means the entire Indian Penal Code goes. No, the other Indian Penal Code parts, they continue. Only section 377 was read down. That is Article 13, Clause 1. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. That's Article 13, Clause 1. Any questions? Very good. Number 2, the state shall not make any law And you know what is a state? Definition provided under Article 12. The state shall not make any law which takes away or abridges the rights conferred by this part. And any law made in contravention of this clause shall, to the extent of such contravention, be void. Judicial review, which we will discuss in great detail in judiciary, which basically means the power of the judiciary to review the laws passed by the parliament or the actions and the acts of the executive. This power of the judiciary that it can review is not mentioned anywhere in the constitution. Nowhere is this term judicial review mentioned. Nowhere is even this power mentioned. But we can trace this concept of judicial review to Article 13 of the Constitution, to Article 13, Clause 1 of the Constitution. How can we trace it? All laws which are in force in this country immediately prior to the commencement of the Constitution, if these laws violate fundamental rights, these laws will be declared void. And the logic is, who will declare them void? Judiciary, which means judiciary has the power of judicial review. Although not mentioned directly, but we can trace this concept. Similarly, Article 13, Clause 2, state cannot make any law. When we say any law, it cannot make any law. And through this law, what it cannot do, it cannot delete a fundamental right. It cannot abridge a fundamental right, which means it cannot modify a fundamental right. And if Parliament does this, if Parliament passes a law deleting a fundamental right, if Parliament passes a law modifying a fundamental right, that will be declared void. By whom? By the judiciary, which means judiciary has the power of judicial review. Because who is the final interpreter of the Constitution? Judiciary. But if the state cannot make any law, what is the definition of this law? When we say the state cannot do this, state cannot do that, what is the definition of that state? The definition is provided under Article 12. When we say the state cannot make any law, what is that law? That is provided under Article 13, Clause 3. Article 13, Clause 3 explains what is this law. Article 13, Clause 3 says, law means ordinance issued by the president, which we will discuss later. Ordinance, order, bylaw, custom, usage, all these are part of laws. And through all these things, you cannot delete, you cannot modify, you cannot abridge a fundamental right. Then came something else. What happened? Madras government, immediately after the commencement of the Constitution in 1951, what it did, it issued an order. Through this order, what it did, it provided reservation for SCs and STs in government, engineering, and medical colleges. Madras government said, we'll issue an order. Through this order, what we will do, we will reserve seats for SCs and STs in government, engineering, and medical colleges. Matter went to the court, Supreme Court. Champak Dorai Rajan versus State of Madras. The petitioner Champak Dorai Rajan said, my lord, I have an issue. Said, what is the issue? Sir, my fundamental rights have been violated. How? Sir, Madras government says there will be reservation of seats in government, engineering, and medical colleges for SCs and STs. Said, so, sir, it violates Article 15. How? Because Article 15 prohibits discrimination on the grounds of caste. there can be no discrimination. The state cannot discriminate against its citizens only on the grounds of caste. But here the state, which is the Madras government, has issued an order and through which it is discriminating against the citizens only on the grounds of caste. That is why it violates my fundamental rights. My lord, please protect me. Why? Because Article 13 Clause 2 gives you the power, because the state shall not make any law to delete a fundamental right, to modify a fundamental right. Supreme Court said, yes, you're right. Madras government, this order is unconstitutional because you're discriminating against the citizens only on the grounds of caste. The government said, what do we do now? Central government said, what do we do now? We need to provide reservation to SCs and STs, which was not originally mentioned in the constitution. Political reservation was mentioned. That means reservation of seats for SCs and STs in Lok Sabha assemblies. It was part of the original constitution. Reservation in jobs for SCs and STs, it was also mentioned in the original constitution. But reservation for SCs and STs in engineering colleges, medical colleges, in educational institutions was not mentioned. Parliament got together, amended the constitution. First Constitutional Amendment Act, 1951. Article 15 was amended. Article 15, Clause 4 was added to the Constitution. And it is this Article 15, Clause 4, which provides for reservation for those who are socially and educationally backward in educational institutions. Matter went to the court again. My lord, I have a question. What's the question? Sir, Parliament has passed a law. And through this law, it has modified a fundamental right. Modified Article 15 of the Constitution. But my lord, Article 13, Clause 2 explicitly states, state cannot make any law. State includes Parliament of India, which means Parliament cannot make any law to modify, to abridge fundamental rights. This time the Parliament has abridged, modified fundamental rights under Article 15 of the Constitution. Supreme Court asked the government, come here. What are you doing? Sir, we have amended Article 15, which is part of fundamental rights. Yes, sir. But Article 13, Clause 2 does not allow you to modify a fundamental right. No, sir, I think it does allow. Sir, how? Sir, it's about interpretation. How? Sir, look at what Article 13, Clause 2 says. What does it say? Sir, it says state cannot make any law. Sir, right, that's what you are doing. You have passed a law. Sir, law is different. Constitutional Amendment Act is different. Because the definition of what is a law is mentioned in Article 13, Clause 3 itself. Through an ordinary law, we cannot delete a fundamental right. Through an ordinary law, we cannot modify a fundamental right. That means through ordinance, through order, through bylaw, through rule, through regulation, through notification, through custom, through usage, we cannot modify, abridge, delete a fundamental right. But sir, please look at Article 13, Clause 3. Is there any mention of a Constitutional Amendment Act? Does the Constitution anywhere mention that law means Constitutional Amendment Act as well? That means even through Constitutional Amendment Act, you cannot delete, modify, abridge a fundamental right. It does not. That means Constitution has clearly differentiated between an ordinary law and a Constitutional Amendment Act. Through an ordinary law, we know we cannot delete, modify, abridge a fundamental right, but only through a Constitutional Amendment Act passed under Article 368. Because a Constitutional Amendment Act is passed under Article 368 of the Constitution. Through this, we can delete, modify, abridge a fundamental right. Because when Constitution says you cannot pass any law, the definition itself is given. But this definition does not include a Constitutional Amendment Act. That means through Constitutional Amendment Act, which is not a law, which is not an ordinary law, we can delete, modify, abridge fundamental right. Supreme Court said, yes, you are right. Law is different. That means all these are part of law. Through these, through ordinance, through bylaw, through custom, through usage, through notification, you cannot delete, modify, abridge a fundamental right. But Constitutional Amendment Act is different altogether. Through this, you can delete, modify, abridge a fundamental right. This case was known as Shankari Prasad versus Union of India. A decade and a half later, Golaknath versus State of Punjab, 1967. It's all about interpretation. Supreme Court said in Golaknath versus State of Punjab, law in Article 13, Clause 2 includes a Constitutional Amendment Act. That means even through a Constitutional Amendment Act, you cannot delete, you cannot modify, you cannot abridge a fundamental right. The government asked the Supreme Court, but sir, in 1951, in Shankari Prasad case, you said law is different, Constitutional Amendment Act is different. Through an ordinary law, you cannot delete, modify, abridge a fundamental right. But through a Constitutional Amendment Act, you can delete, modify, abridge a fundamental right. Gorakhnath case, Supreme Court is saying, no, that's not the correct position. It's about interpretation. Sir, how can you say, even through a Constitutional Amendment Act, you cannot delete, modify, abridge a fundamental right? Supreme Court said, look at Article 13, Clause 2. State cannot pass any law. And when it is any law means rules, orders, bylaws, customs, usages, ordinances, Constitutional Amendment Acts as well. So through Constitutional Amendment Act also, you cannot delete, modify, abridge a fundamental right. Sir, what are you saying? I'm saying fundamental rights are beyond your amending powers. Don't you dare cast an evil eye on fundamental rights. Fundamental rights cannot be deleted, cannot be modified, cannot be abridged. You don't have that power. The government asked the Supreme Court then, sir, there is Article 368, which gives power to the Parliament to amend the Constitution. Supreme Court said, no, I don't think so. Sir, how can you say that it doesn't give the power? The procedure is mentioned in Article 368. Said, what is that procedure? Sir, it says the bill can be introduced in Parliament in either Lok Sabha or Rajya Sabha. Then it should be passed by special majority. If it affects the federal features, we need the ratification by half of the states as well. All this procedure is mentioned. That means this procedure has to be followed by Parliament while amending the Constitution. So how can you say Parliament does not have the power to amend the Constitution? Supreme Court said, look at Article 368, which you are quoting. And look at the title of Article 368. Article 368's title is Procedure for Amendment. Procedure for Amendment. Where is it mentioned in Article 368 that it is the power of the Parliament to amend the Constitution? It only talks about procedure. Said, sir, yes, it talks about only procedure, but procedure for us, Parliament. Otherwise, who will follow this procedure to amend the Constitution? Supreme Court said, we don't know. Maybe you should set up another Constituent Assembly. Another Constituent Assembly, just like it was set up in 1946, which remained in force till 1949, which drafted the Constitution. You can set up a similar Constituent Assembly. And that Constituent Assembly will follow the procedure mentioned in Article 368 to amend the Constitution, to modify the Constitution. You don't have that power. You only have an ordinary legislative power. You can only pass ordinary laws. Constitution, once it is done, it is done. You can pass an ordinary law. You don't have the power to amend fundamental rights. Indira Gandhi was the Prime Minister. She got the Parliament together, said, let's amend the Constitution again. But Madam Gandhi, this will be challenged in the court. So what? We will defend it. Madam Gandhi, what will we do? Let's first amend Article 368. Why, ma'am? Because what did the Supreme Court say? That the title of Article 368 is Procedure for Amendment. Let's change the title of Article 368. How, ma'am? We will revisit this and we will call Article 368 with the title Power of Parliament. To amend the Constitution and the procedure, therefore. Supreme Court said you don't have the power to amend the Constitution because that is not mentioned in the title. We changed the title itself. Title says power of the Parliament to amend the Constitution and the procedure thereof. Madam, that's okay, but Article 13, which says state cannot pass any law to modify, delete, abridge fundamental rights. So don't worry, we will add a clause to Article 13. Madam, what would that clause be? Article 13, Clause 4, inserted by the 24th Constitutional Amendment Act 1971. Nothing in this article shall apply to any amendment of the Constitution made under Article 368. Nothing in this article, because in this article it is mentioned that Parliament cannot make any law to delete, modify, abridge a fundamental right. This will not apply. This restriction will not apply to the law made by the Parliament under Article 368. To the amendment of the Constitution made under Article 368. That means through a Constitutional Amendment Act, Parliament can delete, modify, abridge a fundamental right. Not through an ordinary law, but through a Constitutional Amendment Act. Even this was challenged before the court in a famous case, which we will discuss in great detail next week. Keshavananda Bharti versus State of Kerala, 1973. The Supreme Court said, yes, you are right. Law is different. Constitutional Amendment Act is different. Through an ordinary law, which is ordinance, act, rule, custom, usage, notification, regulation, through these you cannot delete, modify, abridge a fundamental right. But only through a Constitutional Amendment Act passed under Article 368, which requires a tougher majority. Through this you can delete, modify, abridge a fundamental right. But only those fundamental rights which are not part of the basic structure. There are some fundamental rights which are part of the basic structure, which we will discuss later. Those you cannot even touch, modify, abridge, even using Article 368. So long story short, Article 12 talks about the definition of the state. That the state against which your fundamental rights are enforced. Which are these entities of the state? That's mentioned under Article 12. And Article 13 talks about 4 things. Number 1, when this constitution was enacted, when the chapter fundamental rights was provided, prior to that there may be laws which are enforced within the territory of India. If those laws are in agreement with fundamental rights, those laws will continue after the commencement of the constitution as well. But the moment these laws conflict with fundamental rights, are in contravention of fundamental rights, those laws will not continue. But only those clauses of that law which violate fundamental rights, the rest of the law will continue. Doctrine of severability. Sever only those parts, cut only those parts which violate the fundamental rights. And Parliament has the power to modify a fundamental right, to abridge a fundamental right, to delete a fundamental right. But only those rights which are not part of the basic structure. But Parliament can do that only through a Constitutional Amendment Act passed under Article 368, not through an ordinary law, and clearly not through an ordinance, order, bylaw, custom, usage, rules, notifications, regulations, so on and so forth. That is Article 13 of the Constitution. Any questions as of now? Section 124, capital A, violates fundamental rights. How can this law survive in the IPC? That is your assumption. The Supreme Court has said sedition does not violate fundamental rights. In Kedarnath Singh case, in Shreya Singhal case, in so many cases. But right now it is under review. That's a different story. We will discuss this in fundamental rights chapter. But as of now, it does not violate fundamental rights. Section 377 is still enforced. Then this isn't contrary to the judgment of homosexuality, because incest is also the act of mutual consent. If homosexuality is natural, then incest is also natural. You may be right, but courts can only decide on matters which are presented to it. Clear? Nobody argued that even incest should be allowed. When no petitioner argued before the court that please allow incest as well, apart from homosexuality, how can Supreme Court randomly say that even incest is allowed? Although you're right, it involves consent. If in homosexuality there is consent of 2 parties, some people may find it horrible. How can you have a lesbian or gay relationship? But if 2 adults are in a consensual relationship, as a society, we should not interfere. Similarly, if brother and sister are in a consensual relationship, even if you find it horrible, as a society, we should not interfere because these are 2 adults in a consensual relationship. But bestiality can never be allowed. Why? Not that I am pro animals, but I'm pro consent. Animals cannot give consent. Or there is no way in which you can show animal giving consent. As long as consent is involved, everything is okay. Since animals cannot be seen to be showing consent, That's why bestiality should not be allowed. But sir, ordinance can be used to amend constitution in some cases. No case. No case, full stop. Ordinance can never be used to amend the constitution. Sir, if our constitutional rights are violated by government, then what we can do? You can approach the High Court, then you can approach the Supreme Court. Sir, how 368 procedure of amendment doesn't give power to Parliament initially? Because the title mentioned procedure for amendment. The court said, look at Article 368. The title itself says procedure for amendment. It does not give power to the Parliament to amend the constitution. So what we will do, so can Supreme Court never take up suo motu cases? The courts can take suo motu cases on its own. But in this case, it did not take it up. That's also the discretion of the court. There are 8 minutes left in the class. We can't discuss right to equality because it involves an elaborate discussion of about 1 hour. So we can't start it and then leave it midway. What I will do, I will take questions for the remaining 8 minutes. Those who have no questions may go. We will meet tomorrow 6 o'clock in the morning. Those who have questions, please stay. I will take all your doubts till 9:30. After that, I will also go. Okay? But don't go without rating the class if you have enjoyed today's session. Let me know. Sir, in short, we can say Parliament can amend fundamental rights except violating basic structure. Yes. Example of the Supreme Court SC reservation. Was it injustice, sir? We will discuss this tomorrow when we will discuss Article 16. Then you will not think that this is injustice. You will think that this is part of social justice. New CRPC and IPC, please tell about that. That new bill has not been passed yet. Once that is passed, we will discuss. Sir, please answer how Madam Gandhi amended Article 368. Madam Gandhi did not amend Article 368. Parliament amended Article 368. Madam Gandhi was the Prime Minister. How could she have amended? You can still do that. That's for the court then to decide whether this was done legally or illegally. So does Parliament have the power to reverse the order of the Supreme Court? In some cases, yes. If the underlying condition of the judgment is altered. What is the underlying condition of the judgment? For example, Shabano. She was an old lady, more than 60, 70 years old. She was married to an advocate of the Madhya Pradesh High Court. But the husband fell in love with a younger woman and divorced Shabano. Shabano asked for maintenance. But according to the Islamic laws, maintenance could be provided only for 3 months, not for the entire life. She approached to Madhya Pradesh High Court. My lord, I have a doubt. I have a concern. So what's the concern? If my fellow Hindu sister is divorced, she gets maintenance for her entire life. But as a Muslim woman, I get maintenance only for 3 months. Is this not discrimination on the grounds of religion? Madhya Pradesh High Court said, you are right. Shabano's husband, ex-husband, you provide her maintenance for her entire life. Matter went to the Supreme Court. Supreme Court also said the same thing. Provide maintenance for the entire life, not only for 3 months. Then there was a lot of hue and cry amongst the custodians or so-called custodians of the Muslim faith, the clerics, the Molvis. They started protesting, and some of them approached Rajiv Gandhi as well. Rajiv Gandhi, a suave, good-looking gentleman prime minister, he listened to these individuals and ultimately passed a law in the parliament known as Muslim Women Protection of Rights on Divorce Act, 1985. The very logic given by the court was, since compensation is less, that is why this compensation cannot be satisfactory for this woman for her entire life. That is why you have to pay compensation for the entire life. This was the underlying judgment. Parliament in its law said, we will increase the compensation. The maintenance amount will be increased in such a manner that this amount lasts for the entire life. But this amount can be paid only for 3 months, according to the Muslim law, not for the entire life. So Parliament has the power to nullify the judgment of the Supreme Court only if the underlying condition is changed, is altered, is touched upon. Otherwise, no. is fundamental rights enforceable against individuals if they violate my fundamental rights? There are some fundamental rights which are enforceable against this individuals as well, which we will discuss tomorrow. For example, Article 15, Clause 2. No citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth. That we will discuss tomorrow. Can we say if institutes like BCCI violate fundamental rights, one can't directly approach the Supreme Court? You can't approach the Supreme Court. And clearly not on the grounds of violating fundamental rights, because BCCI is not a state. So where can we find the timetable schedule of the classes? On the app? So what is the case of Delhi government reversal of Supreme Court order? That also we will discuss. I gave one example of Shahbano verdict of 1985. We'll discuss the Delhi case when we will talk about union territory. There we will discuss the Delhi case. So section 377 is partially struck down, which means section 377 is read down. Sir, if teen talaq is illegal, then why the people who done this shouldn't be punished? They are punished now, because we have a law passed in 2017 known as Muslim Women Protection of Rights on Marriage Act, according to which if the husband pronounces instant triple talaq, that's what we call teen talaq, instant triple talaq, it's a crime and the husband can be sentenced to 3 years in jail. Sir, if our constitutional rights are violated by government, then what can we do? Vishwas, I think I answered this question before. You can approach the High Court, not Supreme Court directly. If somebody is using abusive language, doing violence on my caste, can I file violation of fundamental rights case directly in the Supreme Court? That would be the violation of the Atrocities Act. If you belong to SC community or ST community, you have to file an FIR. You don't have to approach the Supreme Court. If the police refuses to file an FIR, then you can file a petition before the Supreme Court. Sir, today mentioned Keshavananda Bhati case is different case which discussed earlier regarded for its preamble as part of the Constitution. It's the same case, but so many things were decided by the Supreme Court in that case. That is why you will see this case being cited forever. Statutory rights can be snatched by the government by repealing the law? Absolutely, yes. Okay, that is it for today. See you tomorrow, 6 o'clock in the morning. We'll discuss Articles 14 to 18, which deal with this category, right to equality. See you tomorrow. Till then, have a great time. Bye-bye.